I always call Dan Ditto. So you'll hear me refer to him as Ditto through the presentation. And if you call and ask for Ditto, we'll all know who he is. We do have two Dans here. So we call one Dan and one Ditto. So Ditto, do you want to jump in?
Yeah. So Chris and I, we're real excited to share these with you. These are the things that we most commonly hear problems with from our clients. So we're gonna, and each of these we considered giving a full presentation on. But as we kind of went through, we just said, why don't we start off doing something that will kind of give a basic bit of information on each, so that if our clients run into stuff, they can call us. So this should be relevant to anybody. Good refresher if you're real familiar with HR. So we're going to go over Fair Labor Standards Act, the FLSA, 1099 contractors and differentiating those from W-2 employees, sexual harassment, FMLA, Family Medical Leave Act, the ADA, Americans with Disability Act, workers' compensation, protection for LGBTQ employees, state guidelines for termination, severance agreements, state unemployment insurance, then we'll discuss documentation. So we're going to start off talking about the FLSA, Fair Labor Standards Act. What is it? This is the federal law that governs minimum wage, overtime, record keeping for your employees, and then employing youth employees. This is governed by the Department of Labor, and they have a specific division, the wage and hour division. And so if you get audited on any of these type of things, it's going to come from the wage and hour division. You're probably real familiar with minimum wage. It's not something that very many people don't know about. There's a federal minimum wage at $7.25, but every state is going to have their own as well. So depending on which state you're in, that amount could go as high as $15 or something like that. But the most relevant thing to remember is that is always what your employee has to get paid, including if you're making deductions and that sort of thing. In most cases, you're not allowed to go below the minimum wage on what you can take away from someone. As far as overtime goes, again, pretty common knowledge, but anything over 40 hours a week is the federal requirement to pay a time and a half. Different states have different rules. Some states will have double pay after a certain time. Some have rules about, after 8 hours in a day, any additional hours are going to be overtime. So it's important to know what your overtime rules in your state are. There are exemptions to those rules. Usually they're industry specific or specific based on the type of job and duty. The thing you're always going to want to remember, if there's some sort of question about whether an employee is hourly or salaried, you're always going to want to err on the side of hourly, because if it's that close of a question, the government's probably going to look at it more like they're hourly. So let's talk about record keeping first. Record keeping, I can tell you this is important because one of our clients here recently, they were audited by the State Department in Illinois. The state of Illinois came in and said, hey, we had a complaint about somebody's hours. The very first thing they asked for, all the employee information, their birth date, social security number. You need this stuff anyway in order to file taxes. But it also has to be stored. And there's lots more of that information. If you're working with Ampian HR or you're using some sort of a system, most likely, well, in the case of working with Ampian HR, of course, I can't speak for every system, but most likely you have that information stored away. You want to make sure that you have that handy so that if you needed to pull it to give to a government entity, you could. As we're talking about hourly, it makes sense then that how do you determine hourly? Well, you have to track their hours, right? That's how you're going to determine how to pay them. So if there's a question about hours, you have to be able to pull timekeeping records. These timekeeping records are pretty crucial as far as and they don't when they say timekeeping records, there's not a specific method that they want, but they want to know that you've tracked the time and that you have it in front of them. So some people will use a time tracking clock. Some people will actually just have the employees report the time and sign off on it, which is not a bad practice, but also more difficult to enforce sometimes on HR. But you'll want to be able to produce those. We're going to talk about youth and child labor rules. So this is becoming more relevant because you've probably, a lot of you as employers have noticed that it's become harder and harder to hire. There's fewer available. I actually just read an article the other day about how our youth workers are getting more and more options for work than they've ever had because there's so many jobs available. That means a lot of employers are looking for work wherever they can get it. During the summer especially, they're going to be hiring younger workers a lot of times, especially for retail or restaurants or something like that. Every state is going to have their own specific rules. Violations can be really expensive and time consuming. Time consuming should go without pretty much everything we're going to talk about today. If you get audited or pulled in, besides what you're just going to pay, it's going to take a lot of time. I have a family member who works for the city of Orem. A few years ago, so we're in Utah. Orem's a city in Utah. A few years ago, the Sarah Pools, that it's kind of like a water park that the city owns over there. They used to have all these youth employees, and you have to, with youth employees, depending on your state rules, you usually have to manage them in a certain way. There's different rules for 14-year-olds than there are for 17-year-olds, and they had not done a great job of following those rules. The federal government came in and nailed them, and they had to pay a bunch of fines. And what my family member was telling me is, and it wasn't the fines that were the biggest problem. It was the amount of time that we spent trying to fix it and get information on it. And so basically they just stopped hiring youth anymore. That's what he told me. But it's really not as scary as it sounds. It's just you need to know who your employees are, what ages they are, and apply the proper rules for those ages. So now we're gonna move on to discussing overtime exemptions. This is probably the most common mistake that employers will make as in regards to the Federal Labor Standards Act. And that's misclassifying an employee as salaried versus hourly. So as we said, if there's a question between the two, you don't usually err on the side of salaried, you usually err on the side of hourly. And that's because the government is always going to look at employees as though they are hourly unless you can prove that they're not. So it's up to you as an employer to show, hey, this person qualifies for a salaried position. The most common exemptions are always salaried, but there's definitely a few outside that aren't salaried, like outside sales. Most common of these different type of salaried exemptions are white collar exemptions. So now we'll talk a little bit more about these, an example of kind of how these exemptions break down, which is, Chris, if you could turn the page, the salary basis test is kind of the first step. So, and this is the one that most employers are most familiar with. It's basically you have to pay your employees a certain amount. This has changed a few years ago. It's now $684 a week. It used to be around $400 a week, and they upped that here a few years ago. But it's an important part of the test because the salary is saying, no matter what, in a week, you're going to pay someone this amount. If they worked part of the week, there are a few exceptions to that rule, but it's far and in between, and it's not. You're not going to say, okay, well, this person, they're salaried, but they worked 3 hours today, and so we're only going to pay them for 3 hours. That would be the opposite of salary. Instantly, by doing that, you're basically pushing that person into an hourly position. Doesn't from now on. It's not like that week they were hourly. It's the government if you've ever done that to that employee, they should not be considered salary going forward. That's an important part of the test, but it's not the only part of the test. A lot of people will go, oh yeah, great, we're paying that $34,000 plus a year, so we're good. The part that employers get nailed on probably the most is the duties test. This is where it actually matters what your employee does for you. If they're an executive, they're going to fall under an executive exemption. If they have more discretion, and if they work in an office desk, and if they're a manager, then they may have the discretion that arises to one of the exemptions. A lot of times, the education in an advanced field of knowledge, so like a doctor, would be able to be considered under an exemption. Also, creative field, someone who's like a graphic designer or something like that. But the thing that, so I'll use executive as an example. Thing that employers get tripped up about it, they think, oh, well, we have this executive assistant, for example. It's even in the name, she's an executive assistant. Well, that executive assistant is not an executive, really, not in what she's actually doing. She's actually more of a secretary. And she really is told what to do all day long. She doesn't have a ton of discretion in matters that are really pivotal to the company. The other thing you'll get in trouble with here is, take like a foreman on a construction site. Is that person's job actually being the foreman, or is it doing some type of manual labor? This matters because that's something you'll weigh. You'll look and you'll say, okay, well, 30% of the time they're being a foreman. That's probably not enough time to be considered, salaried under the basis test for a manager. Sorry, not under the basis test, under the duties test for a manager. So it's really gonna matter what they're doing with their time. If they're managing employees most of the time, they can hire and fire, that sort of thing. That guy might fall under an exemption. And I'm not going into all of these individual exemptions because there's a whole bunch of them, but it's really relevant because if you got audited, to have the job description and say, see, this is where this person's going to fall under this specific exemption. So if you've never done that for your salaried employees, you really want to audit those job descriptions and just talk about, okay, what can we do to fix this going forward? Because you look like a rock star if they come in, they're auditing you, and you say, oh, look, here we go. Here's the job titles that we've already looked through, and it lines up with this exemption that we want to use. Yeah, so just after each section, we're going to have this little how Ampion can help you. It's not really an advertising tool because most of you are our clients. What we're just trying to do is make you aware of what we might be able to do to help you through the process. We're not going to read through each of these because that could be time consuming. I'm not sure super relevant to each topic, but like JJ said, you'll be able to go in and get this. So as you go back and you look through and you say, okay, what could I do with Ampion to kind of help me with this problem? We just wanted you to be aware of that. So we'll move on now to contractors versus W-2 employees. This is a question almost weekly I get asked about. So it was one that I wanted to cover at least. Now, my job here is not to tell you, okay, here's the tricks to making sure that this person looks like a contractor if they're actually a W-2 employee. What I'm trying to share is more of this person, if they're doing these things, is a W-2 employee. If they're not, they're a contractor. So it helps you know how to refer to and treat and use that individual. Misclassifying employees and contractors is a huge DOL violation. It's something that is going to take a ton of time because they won't just look at one person. They'll look at all of those relationships, and they're going to be suspect. If there's one that looks off, they're going to consider them all suspect. So they're going to go through them with a fine tooth comb, and then you're kind of back in that same situation you would be with salaried, where you're on the defensive. You have to justify each of these relationships, and it's not a question of, hey, I'm an employer, I want to hire a contractor. Hey, this is a person who wants to be a contractor for me, or be paid as a contractor. So we're going to hire them as a contractor. It's a little bit more complicated than that, and it'll come down to this. If you see below on the page or low on the page, it says economics reality test. This is the test they use, and it's a little bit tough as an employer because it's not completely cut and dry, but it's definitely going to lean towards W-2 employees, especially with this new administration who, if you've followed any of Kamala Harris's career, she was really, really pro turning contractors into W-2 employees in California. So let's go through this economics reality test a little bit. It's basically going to look at the behavioral relationship between the employee and the employer, or I should say the contractor and the employee, and whether what kind of control the employer has or the business has. Financial, what sphere of influence does a business have over that contractor's economic opportunities, if you will. And then the type of the relationship, what else is being given? Are benefits being offered? What's the length of the contract? What is there documentation and an actual contract? So we'll get a little bit more into this on the next page, which is so what they basically want to see, and I've been to meetings with DOL individuals on this, the Department of Labor. They want to see somebody, a contractor, who looks like their own business. And that means that person is ideally licensed as a business. They're an LLC or an Inc. They use their own tools and equipment, so they're not coming in. If it was like a construction site, they would come in with their own tools. They wouldn't, come in and then use your machines. Does the contractor have control of his or her own hours and hour worked discretion? This is a really big one, because if you're holding somebody accountable, hey, you weren't here at 9 a.m. And you weren't here till 5, I can tell you that's just going to be an employee. Does the contractor have multiple clients? Sometimes this one's tough, because if they're just started out as a contractor, you might be their only client. But and this kind of feeds into the next one. Are they promoting themselves to grow as a business? So do they have a website? Are they putting advertisement up? And do they invoice you for work versus getting paid through payroll? Let's go on to the next one. So I just thought I'd include some no-nos against this. Again, this isn't for you to beat the system. This is just because the problems with these situations arise because of miscommunication and misunderstanding. If you are calling a contractor an employee or a contract employee, that's already going to be suspect. Like, that's going to set off red flags for the government. It's also the reason that employees or people who are contractors think they're employees, and that's going to send them down the road where they're like, man, I've had to pay all these taxes, and they talk to their cousin who's in HR or a lawyer, and that or just knows the process, and that person says, you should be paid as an employee, not as a contractor. You should report these guys now that they fired you, or you're not working with them. So don't pay them through payroll, because that's what you do for an employee. You'd never go and pay your plumber that you brought in to fix something in your business as through payroll. You write them a check for their invoice. You don't provide them with benefits. That's, again, not something you would do with somebody who's a contractor. You don't discipline them or write them up. That's something you do with an employee. If you have a problem with your contract, you either adjust the contract, you enforce the contract, you talk to them and say, hey, what can we do to resolve this problem? Or you terminate the contract. You require them at meetings. Meetings are for employees. That's control over their schedule. Just like anything that's going to have control over the schedule is going to make you look like you hired an employee, and you should be paying them as an employee and paying taxes on them.
Hey, Ditto, can I just pipe
Chris,
in here
jump
and
in.
make it conversation? So I think that a lot of times employers will feel like this works until it doesn't work. So let me give you an example of that. We had a situation where one of our clients was paying an individual as a contractor and let her go, and she filed for unemployment. Well, of course, she's not eligible for unemployment because she was a contractor, and Ampion or the client were not paying the quarterly unemployment tax rates for that employee. And so the employee starts having conversations with people and says, well, I sat in their office, they provided me with a desk, I used their computer, I used the copy machine that was right behind me. I feel like I should have been an employee. And so even though the employee and the employer might have an agreement of how that's going to work, if that goes bad or the relationship ends in a negative way, just know the lens that contractor has the potential to look through. And if they can prove that you treated them very much like you treat all your other employees, that's going to be a problem.
Yeah, Chris is dead on that, because the reason this arises is something happens in that employee's life that really is impactful to them. Maybe they're injured on your work site. Maybe they're they have a health problem and they don't know what to do, and they're like, man, I don't even have health insurance. They start talking to somebody and telling them about the relationship they have with your business, and it sounds like you're an employee, and that person says, well, do they offer health insurance? And you're like, well, I don't know, I'm a contractor. Well, you probably should be an employee. Those things are so dangerous for employers, because down the road, besides just being audited by the DOL, which eventually that will lead to, they also can hold you accountable for workers' comp. They can hold you accountable for benefits they should have been offered. You can imagine going back and trying to figure those things out is a complete mess. So yeah, just make sure that you classify the individuals right. It's not worth classifying them as contractors and then taking the risk where they really should have been W-2 employees.
Okay, next topic we're going to talk about is sexual harassment. So as you all know, this has been a really important topic and a more highly publicized and highly litigated topic since the 80s. So it's important that you understand that there's liability associated with your handling of a sexual harassment complaint or concern in your workplace. While training is not required by federal law, several states have enacted legislation requiring sexual harassment training, and it's recommended by the EEOC, the Equal Employment Opportunity Commission, that employees be trained, but specifically that managers be trained. At a minimum, anyone in a supervisory or management position should receive training about what sexual harassment is, how to prevent it, and what to do if there is a complaint. Both the manager individually and the company have liability if the concern is not properly handled. And there's actually civil liability here. So it's not just the company being sued, but an individual manager can be sued civilly if they mishandle a sexual harassment complaint. So what is sexual harassment? The base definition is unwelcome sexual advances and or requests for sexual favors. However, other verbal or physical conduct is included, especially if it causes stress or anxiety for an employee or causes a hostile or offensive work environment. I think it's important to note that sexual harassment in the workplace harms everyone. So this goes far beyond the reach of your office walls. Employees that are sexually harassed in the workplace or work in a hostile work environment generally take that home into their home life, and they discuss it with spouses or family members or children, and it can cause a lot of anxiety for those individuals as well. We really do have a responsibility as business owners and leaders to provide our employees with a safe work environment where they are treated with dignity and respect, and we don't tolerate people that would create that type of environment. Engaging in or not reporting sexual harassment is actually a violation of Title VII of the Civil Rights Act. So it's not just a bad idea, but it's actually illegal to do nothing. For an employee, for an employer, the liability may be federal, state, individual, or as I mentioned earlier, civil litigation. The company is responsible for harassment by a supervisor or manager that results in tangible employment actions. So something like an employee was fired, or they were demoted, or there was a change in their schedule to a less desirable shift, an effect on their pay or benefits. All of those could result in fines if an employer is to be found guilty of sexual harassment or protecting a manager. If you take one thing away from this slide, please let it be the first bullet, because for me, this would be this would be the worst case scenario, right? So this slide talks about the EEOC remedies for sexual harassment or a sex discrimination suit. You may be required to reinstate the employee. So think about how that would feel if you had sexual harassment in your workplace, the employee leaves for whatever reason, they sue you, you lose, and then you have to rehire them back. I mean, in my mind, that's just the worst case employment scenario that could happen. But not only that, there's all of the back pay, compensatory damages, punitive damages, liquidated damages. So it is a very expensive lawsuit. So that's really just kind of a quick overview for you of the liability that can be created by improperly handling a complaint or a concern of sexual harassment in your workplace. And if you have a situation that arises and you want some counsel, please reach out to us. We can help you, figure out how to investigate. We can help make sure you have a proper policy in place. That is our job, and we would be happy to help you with that. The next topic I'm going to talk about is FMLA. FMLA is, I feel like it's always one of those policies that the employers get a little bit worried about, especially because I know in the past there's been some abuse of FMLA and things like that. But my job is to help reduce that fear or that worry for you. FMLA was passed in 1998 by the Clinton administration. And while there have been some program expansions over the year, the basis of the program is still intact as it initially was. But I will let you know now that we have heard that President Biden has thoughts about changes that he'd like to make to the FMLA. We're very engaged with our legislators in Washington, D.C., and are very in tune with the changes that are happening there. So if there are changes, we'll definitely let you know. But of all the federally governed employment laws, FMLA is probably the one that is most beneficial to employees. And I feel like many employers and employees think they understand how it works, but there's also a lot of misperception about the program, and there's a lot of tasks associated with FMLA. So how do you know if your business is required to offer FMLA? Well, in general, it's pretty easy. The definition of a covered employer is that the employer employs 50 or more employees. Now, there may be other factors if there are several smaller businesses with common ownership or a situation like that. But part of our role would be to help you analyze that to determine if you are a covered employer. So once we know that the employer is a covered employer, then we need to determine if the employee is eligible. And there are a couple of different factors that we look at. First, the employee works for a covered employer, and the employee has been employed by the employer for at least 12 months and has worked at least 1,250 hours of service for the employer in the preceding 12 months. So again, if they haven't been there for a year, FMLA is off the table. They're not eligible, and we would not offer that. The 1,250 hours of service averages out to be about 24 hours a week, but we would analyze that to make sure that they are qualified for that. And then finally, they work at a location where the employer has at least 50 employees within 75-mile radius. So we have a client that has 42 employees in Salt Lake and 12 employees in Chicago. While they're technically over 50, they do not meet the 75-mile distance minimum, and therefore FMLA doesn't apply to any of those employees. However, if the client has 51 employees in Salt Lake and 8 in Chicago, then all employees, both Salt Lake and Chicago, would be eligible for FMLA. So hopefully I didn't just make that more complicated than it needed to be. This slide provides an overview of the basic qualifying reasons for FMLA. We're not going to spend a lot of time here, but it's important for you to know that the basic qualifiers, what are the basic qualifiers and where to go or how to get more information on FMLA if you have an employee that you think might qualify. So one of the most common reasons that I think we hear about is a provision for the birth of a child or to care for a newborn baby. Number two, to care for replacement with the employee, so in their home, of a child for adoption or foster care. Number 3, to care for a spouse, child, or parent with a serious illness. Number 4 is because of the employee's own serious illness that makes them unable to perform the essential functions of their job. And the final 2 are to care for covered military service members and or their dependents. So we won't spend a lot of time on that, but if you have that situation, please reach out. We'd be happy to chat with you about how to handle that situation, and we have more details on that. So again, this is a very scaled back overview of the FMLA process, but I would say, please let us help you. As I'm sure you can imagine, there are many more details that we can provide for you related to things like communication, medical certification, tracking of the time off. And I would be happy to help consult with you and partner with you on all the various aspects of the FMLA requirements. The next one is similar. This is the ADA, the Americans with Disabilities Act. This act was signed into law in 1990 under the George H.W. Bush administration and was the first comprehensive civil rights act in this country that addressed individuals with disabilities. So this program applies to employers with 15 or more employees. So for many of you that are participating today, you probably have a responsibility to govern your work site using the ADA. The key aspect of the ADA is to prohibit discrimination to those with disabilities. And the ADA also requires employers to make reasonable accommodation to applicants or employees if needed to perform the essential functions of their job. This is key because there can be a significant amount of analysis to determine what a reasonable accommodation is, and that is something that we can help you with. This slide is kind of an overview of the various aspects of the ADA that apply to your business's employment practices. So you should be keenly aware of your processes in each of these areas to ensure there are no discriminatory practices. In addition, the ADA prohibits retaliation against applicants or employees for asserting their rights under the ADA. So an example of retaliation in this case would be that an employee requests an accommodation under the ADA, and then the following week, the employer decides they no longer need that employee and they lay them off or terminate their employment. That would be a violation of this law. The ADA also prohibits employers from discriminating against an applicant or employee because of some decision not related to the position. So an example I thought of in this case is that they have an association with a disabled person. So you have an applicant, a candidate. I happen to know that this applicant's wife has a disability, and I think that may prevent this candidate from being at work every day or having to deal with his wife's, medical issues. So based upon that, I would probably not want to hire them. Again, that would be a violation under the ADA and would be illegal to do. So while we're not getting into all the aspects of the ADA today, I want to give you an idea of who is considered a covered individual under the ADA. Covered individuals include both applicants and employees that can perform the essential functions of a job with or without reasonable accommodation. In addition, those disabilities can be physical or mental. So this is not just limited to those disabilities that we can see with our eyes. So it is important to have a policy related to ADA, and that your managers and leaders should understand what it is and how it works so they can help you kind of be the eyes and the ears of your business in case there is a situation where an ADA would need to be offered to an employee.
Chris, let me just chime in too
Yeah.
and say all the things that Chris has covered, one of the reasons we wanted to bring them to the attention of our client employers and anyone else on the website is because there's an interactive process that you have there with your employee, whether it's sexual harassment allegations, whether it's FMLA because somebody's sick, or whether it's somebody's got a disability in your work site. Standing back and doing nothing as an employer is going to get you in trouble usually. So you need to go through a process with that individual if they come to you and tell you about one of those things, rather than just kind of dictate an outcome, if that makes sense. So let me jump into workers' compensation. I'm just going to keep this one short. Probably a lot of you are pretty familiar with it. It is required by law. Every state has different mandates, but every state has it. So it's really something that you're always going to need. Some states have their own pool, and every employer is going to pay into that pool through kind of a tax almost. In most states, you're going to get your own policy through a carrier, an insurance carrier, and then apply that as your employees go through injuries. Every injury should be reported, ideally written down somewhere. I mean, if it's small and we're talking about a cut on a finger, you do you write it up quick, you have the employee sign it. If they don't need to go in anywhere, that's fine. Any injury that looks like it may be any kind of more serious, you send somebody somewhere, and ideally that's most of the time. This protects you because these injuries, even small, you kind of think somebody falls down, they bang their head or something like that. You think, oh well, it's no big deal. They feel fine about it. Well, these come back to bite employers all the time, especially where there's witnesses, and a lot of people can attest that it happened. The witnesses are a good thing, but they can play against you if you haven't filed a workers' comp claim. It also helps you avoid, basically insurance is going to require you to report injuries. So if you're not reporting some injuries and paying for them yourself or that sort of thing, then that can be considered insurance fraud. And that's the type of I can tell you I've run into this issue, not insurance fraud itself, but run into an issue where an employee from 3 years before with an employer comes back and says, yeah, my head that I banged on the floor at your facility, it still hurts, and I think I'm going to need major surgery and major drugs for the rest of my life, and I should have gotten workers' comp through you guys. Well, that's, first of all, it's really hard for the carriers to track what's happened in the last 3 years. I mean, they could have banged their head 100 times, you wouldn't know about it, and it could be all of off-site, off of your work site. But now they're coming in and they're saying that they deserve this. Well, in this situation, there had been a bunch of witnesses, so it was well documented that it happened. Fortunately, this employer had paperwork that the employee had signed where the employee said, no, I'm not going to go in and get treated. I don't want to receive treatment for this. So that took away the liability, but that easily could have gone the other direction. I would expect a lot of times with employers that goes the other direction, because it's just easier for employers not to have logged that injury than to log it and kind of go through the process. These also need to be tracked for annual OSHA reporting. OSHA can come down hard on employers if you don't have that reporting mechanism in place, and that's something that Ampion does do for its clients. So just make sure that the main takeaway here is, if somebody's injured, do something. Make sure that they're taken care of. Make sure they, in most circumstances, go in and receive care.
And even honestly, even if that something is like, oh my gosh, I remember Ampion talking about this on the webinar, I'm going to call Ditto or Chris. That's great. Just do something. I agree. Great feedback. Okay. All right. I'm going to jump back in here to talk about the EEO. The EEOC, which is the Equal Employment Opportunity Commission, enforces federal law as it relates to employment discrimination. And these laws protect employees and job applicants against employment discrimination that involves unfair treatment because of that individual's race, color, religion, sex, national origin, age, disability, or genetic information. The EEOC also protects employees from harassment by managers or coworkers based on that same demographic, those same reasons. They also protect a denial of workplace accommodations because of an employee's race, color, religion, etc. And it protects employees from retaliation because an employee complained about discrimination or assisted with an investigation or a lawsuit. The EEOC has made it super easy, you guys, for employees to file a charge of discrimination. It is a click of a link on their website. And when you go to their website, it gives the employee all the information they need to prepare to file a claim and to file the claim. If you are an employer or HR and are not familiar with this website, please go check it out. I would recommend that for you. Take a look and just know what is out there. It lays out all kinds of information for employees on the various types of discrimination claims that one can file, the timeline for employees, what employers can or cannot do to you for filing a claim. So the reason I want you to know about it is because there's a good chance that one or more of your employees knows about it, and you just need to know, kind of what that is for you as an employer. Now, just because the EEOC accepts a charge doesn't mean that the government is accusing you or that they're making any assumptions. It's just advising you that someone has filed a charge against you and the EEOC is going to investigate you. That is not a good feeling. I will also tell you that this process is extremely time consuming and extremely expensive. I would not recommend that you try to respond to a claim without legal counsel because you'll be far more likely to prevail in a discrimination charge with the assistance of counsel. So these are a big deal for employers. I don't think we spend quite enough time focusing on this, but please get very familiar with the EEOC and what they govern. The EEOC also enforces record keeping, whether or not a charge has been filed. But if a charge is filed, the EEOC collects a ton of information from the employer. So record keeping in the various aspects of your business is critical. Things like the applicant flow, who's applying for jobs, how you make those decisions, who's involved in those decisions. Are those decisions documented? Do you have an employee handbook? Have your employees signed your employee handbook? What is your process for corrective action or termination? Who's involved in that process? A history of employees that you have terminated and the reasons for those terminations. All of those things are part of that discrimination charge process. Also, employers should have the federal law postings in their facilities where employees can see them. And they should have a policy in their handbook related to, fair employment of employees and non-discrimination. So those are all things that we're happy to help you with. That's a really important employment law process. Okay. The next slide I want to cover is some updates to the Civil Rights Act of 1964 as it relates to protection of those in our LGBTQ community. It may surprise you to know that in June 2020, so just a year ago, the Supreme Court decided that the same protections that have been in place for people of different races, color, religion, sex, etc., since 1964. So the same protections that have been in place for 56 years are now available to those in our gay, lesbian, and transgender communities. So prior to last year's change, more than half the states in the union allowed discrimination and employment action against these individuals. So it's no longer legal to take employment action against an employee just because they are gay, lesbian, transgender, etc. Okay, ditto. Back to you.
So something that we've run into issues with is employers not realizing that there's quite a few steps to take when you terminate an employee. Termination is the end of a relationship. It's in many states that triggers several events. So, and depending on the state, that's going to change. One of the big ones is final paycheck. that's going to be different in every state. So in some states, you're going to have to pay somebody out in 24 hours if you've let them go, fired them, terminate them. If in others it'll be 3 days, and in others they'll just say, oh, whenever your next payroll is, that's when you need to pay them out. So there's quite a bit of variation there. You want to be aware of what your state's requirements are, because if they're 24 hours, you want to get on top of that. Otherwise, you could be reported by your employee, and then penalties start to accrue. And then also things like benefits. You want to close out those benefits for an employee. Make sure that that the right steps are taken. PTO. Some states actually will require that you pay out PTO. Whether or not in most states that's up to the employer, but some states actually have requirements. Nevada's put that in place where if you are offering PTO, then you have to follow a certain amount of payout rule. Deductions and pay. This is we talked about this earlier with things like minimum wage and salaried positions and that sort of thing. Depending on the circumstances, some states will not allow any deductions. Frequently, they only allow them in certain situations, and then again, minimum wage will apply. So if you have an employee that you need to pay $500, but they didn't return a laptop, you have to look at that and see if your state is going to allow you, and the federal government's going to allow you to take them below minimum wage on a deduction. Most likely they aren't, so you have to look at what you can, if anything, deduct from their pay for those items that they haven't returned. And then paperwork involved. So Chris talked about methods of different discrimination. Paperwork is helpful in making sure that you've gone through that process, that you've written people up for the right reason. You write up, you have something written about the termination itself. It also helps with unemployment and any other kind of protections that the employer might want. But yeah, these are really important. You can imagine, if you don't close out benefits, for instance, and time goes on, and then that creates some sort of problem, the employer may be on the hook for those benefits, or the employee may be in a really disadvantaged situation that you may have had to offer something, depending on the state you're in. And this is something that we obviously, we prefer to be aware when our clients terminate someone, so that we can start to take those actions on their behalf. Jumping on to the next slide. And you might have noticed we've kind of gone through the life cycle of an employee's employment here. But another thing that'll come up at termination is severance agreements. And there's lots of reasons. So I don't share severance agreements here because I'm super pro severance agreements. It's because there's many situations where I would actually say, I don't think that you want to offer a severance package here. And you hate to offer one, especially if the employee is like, well, if you don't pay me something to leave, I'm going to blackmail you. And I'm going to tell all your clients that you're terrible or something like that. But there's reasons that severance agreements can be a good tool. They're not required, but you can protect yourself in certain ways. They're going to have to go through. Not everything is allowed to be included in a severance agreement, and every state is going to have specific laws. If they're not applied, then that severance agreement is going to be void. Pretty much all states, I believe, are required now to give the employee 30 days to revoke, which employers don't like, because they think that it's resolved, and instead an employee could come back 3 weeks later and say, no, I've changed my mind. I don't want to accept the severance package. There are some things you can do there, as far as like telling the employee, well, we're not going to pay it out until the 30 days are over, or that sort of thing. But that's just, if you don't have that clause in there, that 30 days clause, for example, that contract's going to be void. So if you're using the severance agreement as a protection for your business, well, you want to have those type of things in there. But they're excellent for writing off quite a few of the things that employees could come back and sue you for, or claim, and say like, yeah, I should have been paid more, or I was discriminated against, or and some of those things you're not going to be allowed to do. Again, depending on the state, and some of the things you will. But you want to be careful to also not create a precedence and have what looks like discrimination. If you're offering severance agreements to everybody, and then you withhold it from somebody, that's where you might end up looking like you're discriminating against someone. But yeah, I mean, they're useful tools. Just that's something that we've employed or we've contracted with lawyers to write these for us, and then we make adjustments to them based on what your business needs, and then and we counsel with you on that. And so it's definitely an interactive process with us if you have something like that occur and you want to offer severance.
Okay, we are getting close to being done, guys. So most of you likely know how unemployment insurance is and how it works, but I do know that we have some individuals on the call that joined today that are not currently clients of Ampion. And so I just want to give you a brief overview of unemployment and why we care about unemployment. Any of you that are my clients have probably heard me talking about unemployment, and it's a big deal in my job, and I want to share with you why it's a big deal. So unemployment is temporary financial assistance to workers who have lost their job through no fault of their own. So a great example of when unemployment was super high last year, we had a pandemic, and many people lost their jobs through no fault of their own. They were displaced due to a downturn of business. Maybe their restaurant closed, or went down to a very skeleton crew. Whatever it was, millions of people lost their jobs, and we are more than happy to help employees receive that assistance if it's a situation like that. The liability comes in when employees are granted unemployment, specifically if that employee was terminated for cause. So if an employee is terminating for cause, meaning they were fired or discharged, they should not be eligible for unemployment benefits. Those dollars should be reserved for those that lose their jobs through no fault of their own. So my job here at Ampion is to make sure that I'm helping you minimize any undue cost to your SUTA rate. So the SUTA rate is the State Unemployment Tax Act, and this is a quarterly tax that's paid by the employer. So if you are a client of Ampion, Ampion files those taxes on our client's behalf each quarter. And then as unemployment claims are won or lost, your SUTA rate increases or decreases over time. So my job and my goal is to really keep our costs low, and in turn keep our clients' costs low. Our goal is to avoid paying unemployment benefits to former employees who are terminated for just cause. So my job, again, is to prepare you and create the documentation on those individuals that are dismissed for cause. And that's how I reduce liability for you, and I also reduce liability for Ampion. So what can you do to keep your SUTA rate from rising? There's a lot. First, make sure that your managers are trained and know how to deliver feedback and have critical conversations. And I have training that I do for managers, and that can be very helpful for your managers. I'd be happy to talk with you and schedule a time for that training. Also, that you have a documented disciplinary process where employees know and understand the steps of corrective action and know that there will be consequences if they don't follow the way the company governs them using the employee handbook. Have an employee handbook, make sure that it's current and that employees have acknowledged it. Also, addressing issues at the first sign of concern is really important and is key to keeping your SUTA rate low. Why? Because what we're doing when we are addressing those issues at the first sign is we're weeding our garden early and not allowing the weed to take over the garden. So watching as those weeds sprout up, watching those red flags is really critical. And it's a lot easier to avoid those red flags, especially at a time when we're pressed for workers, but not addressing those red flags and leaving the weeds creates more work on the end. And I feel like, people, employers especially, and I totally understand this, but oftentimes they don't have those tough conversations early on because they assume the employee will just get better, or they will begin to fit in better, their attitude will improve. They have high hopes, I would say. But the problem is red flags early, especially within that 30, 60, 90-day time period, is very concerning, and we need to be addressing those red flags. So really, please call me. I say involve me early and often. My preference is that you call me, text me, email me at the first red flag, and I'll help you document. I'll help you and your managers prepare to resolve employees' issues in the workplace, and we'll keep those pseudo rates low, keep fees low.
Unemployment is such a good one to end on, I'll say, because everything you do to like keep your pseudo rate from getting nailed is going to help you in every other thing that we've talked about.
Agreed. And then my final slide, and clients will not be surprised by this being my final word, and that is on documentation. So throughout the employee life cycle, there are many, many opportunities to properly document your employee's employment with you. That can happen through the hiring process, evaluating performance reviews. If you do a 90-day review to see how people are fitting in, training that you do with your employees, that's all documentation of things that you're doing to make sure your employees are capable and handling things. Corrective action, verbal warnings, written warnings, suspension, we document all of those things well, and there's many more opportunities for documentation as well. So clear and complete documentation is really important for employee management and successful dismissal of an employee for cause. If it's not documented, it didn't happen. So I'm going to pop over the chat here. I think that was our last thing. We're a couple minutes over. Tina asked, are we sending out a copy of the slides? Yes, we will. Oh, yeah, answered that. And then Brenda, we can talk about sexual harassment training. And then there was a question about when I was back on the sexual harassment slide. So my question is, you heard about it and didn't do anything about it because it was not substantiated. So, there must have been a concern or a complaint filed with this employer about a concern that an employee had. What I would say is be careful about your assumptions that it is not substantiated, and be able to prove clearly what your investigation process was, because you would need to have an investigation process to look into what that claim was and who was involved in that, what were the documents associated with that. Did you consult with HR? Did you consult with Ampian? And, being able to prove without a shadow of a doubt that we did a full investigation on that claim or that concern would be really, really important. Hopefully that answers the question. All right, JJ?
If there's other questions, you can always reach out afterwards as well if something comes up. Call and ask for Chris and Dan, or email them as well. We will send out a copy of the slides and a recording of this as well. Thank you so much, everybody that participated. It was great having you listening in. We're here if you need us. Enjoy the rest of your Tuesday.
Thanks, everyone.
Thanks, everybody.